Well, I think the next time I see the word law, which is probably every 5 to 10 seconds when I'm reading a document, it's going to jump out at me as land, air, and water. So I don't know what that's going to do to my levels of concentration in future. We face a global environmental challenge, and that's the challenge of anthropogenic climate change. As an island nation, we're literally on the front line of one of the principal effects of climate change, namely rising sea levels around the world. In December 2023, the Alliance of Small Island States, and of course we're a member of that alliance said of the draft of the final agreement at COP28, we will not sign our death certificate. We cannot sign on to text that does not have strong commitments on phasing out fossil fuels. And more recently, Singapore submitted a written statement to the ICJ, the International Court of Justice, in its ongoing case, the ICJ's ongoing case on the obligations of states in respect of climate change. In a press statement on that ICJ proceeding earlier this year, our Ministry of Foreign Affairs explained that as Singapore is especially vulnerable to the impacts of climate change, we are committed to participating in collective, multilateral, and rules-based efforts to seek solutions founded upon international law to address climate change. In our daily lives, well, this is a little slide, and I do hope that the talks that continue can speed up a little and do not retain their glacial speed. In our daily lives, we rely upon the rule of law to structure many aspects of our existence, from our contracts with our employers to the goods and services we purchase, to the personal injuries or property damages we sustain on the road. And this applies, the same principle applies to our response to international ecological challenges. So our climate policy flows from a developing global consensus concerning the environment. And that can be summed up in this: mankind is not the environment's master, but its steward. And we are responsible for the environmental welfare of future generations and for other creatures and the earth generally. And this policy informs the court's adjudicative role. I now turn to address the challenges that I've outlined in 3 parts. First, the role that judges and courts play in adjudicating claims in the area of environmental law and climate change litigation. Secondly, the environmental rule of law in the context of issues concerning conservation of biodiversity in the ecosystem. And finally, I'll turn to the tricky task of human beings living with nature and embracing acceptance of wild animals in our midst. Public interest environmental litigation is becoming increasingly frequent. In the right circumstances and under the right legal framework, such lawsuits can be effective. And I begin with the decision of the Hague District Court in the Netherlands in Milieu Defensie and Royal Dutch Shell, Milieu Defensie and Shell, handed down on 26 May 2021. Now, there is an outstanding appeal against this decision lodged by Shell, which has been heard this year, and a decision is expected perhaps later this year. But let me talk about the court's first instance decision. The court held that Shell had to reduce its emissions by 45% by 2030, based on the unwritten standard of care found in the Dutch Civil Code. And I quote from the judgment, "An important characteristic of the imminent environmental damage in the Netherlands and the Wadden region, a low-lying part of the Netherlands, at issue here is that every emission of CO2 and other greenhouse gases anywhere in the world and caused in whatever manner contributes to this damage and its increase." And from that, they concluded that an omission on Shell's part to take necessary steps to reduce its CO2 emissions in line with Paris Agreement targets would violate its unwritten duty of care owed to victims of climate change and global warming, including residents of the Wadden region. In their words again, much may be expected of Shell, which of course is a Dutch company, in this regard, considering it is the policy-setting head of the Shell Group, a major player on the fossil fuel market and responsible for significant CO2 emissions, which incidentally exceed the emissions of many states and which contributes to global warming and climate change in the Netherlands and the Wadden region. That's the Netherlands. In common law countries, there has been litigation brought by activist shareholders against directors, positioning neglect of environmental targets in the business of a company as a potential breach of directors' duties to act in the best interests of the company. That's one of the fundamental principles of corporate law, that directors must act in the best interests of their company. And an example is Client Earth and Shell again. This was a lawsuit brought by an environmental law organization, Client Earth, against the directors of Shell before the English High Court. The allegation was that they were breaching their directors' duties for failing to take adequate steps to reduce greenhouse gas emissions in order to comply with the targets set out in the Paris Agreement, failing to take practical steps, having already considered that Shell needed a policy that would enable them to comply with those targets. Now, Client Earth sued as a shareholder, but they'd acquired just 27 shares, and you can imagine there are a lot of shares in a company like Shell. Normally, directors do not owe fiduciary duties to shareholders directly. They owe them to the company as a separate legal entity. So what a shareholder can do is to seek the permission of the court to bring what's known as a derivative action, effectively standing in the shoes of the company. Now, whether to grant that permission depends on the court's exercise of its discretion. Now, the conclusion that the English High Court reached was that Client Earth was not acting in good faith. The court considered that the real reason behind the lawsuit was to pursue Client Earth's activist policy agenda and not to remedy mismanagement that prejudiced the members' interests. Accordingly, the High Court refused permission to commence a derivative action. Permission to appeal was refused. And Client Earth's response in their press release of late last year was that the courts had missed a critical opportunity to grapple with the enormity of the climate crisis and clarify directors' legal duties in light of the significant risks it presents to companies and shareholder value. Now, this case offers the reminder that the courts do not enter the policy arena except when this is clearly mandated by the legal framework. And our own Chief Justice, Sundaresh Menon, has described this as a posture of judicial modesty, recognizing that our role is limited to the adjudication of rights and obligations based on the content of the law and not a judge's own personal leanings or policy preferences. Nonetheless, under the right circumstances, an environmental lawsuit may succeed. How we understand the meaning of legal rules is often shaped by present circumstances, including and especially the pressing problems of the present. As International Judge James Alsop of the Singapore International Commercial Court put it in his own discussion of climate change litigation, legal policy to develop the law, drawn in part from the necessities of the age, will always be present in the judicial task. Indeed, in the very recent case of Smith and Fonterra, the New Zealand Supreme Court confirmed the potential relevance of tikanga Maori customary law, its relevance to informing the common law in its approach to climate change claims. And this is an example of older customary systems which might have a different relationship to land, air, and water than that taken by the common law system, which of course is based very much in its origins on the principle that we are masters of our environment. And that different approach to stewardship and a gentler, more in tune relationship with the environment in customary law systems is finding its way at least into New Zealand common law. Well, what explains the difference in the outcomes of Client Earth and Shell and Milieu-Defensie and Shell? In Client Earth and Shell, the plaintiff was attempting to assert the derivative rights of a shareholder, seeking permission to stand in the shoes of a company to vindicate the company's rights as its shareholder, but was held not to be seeking to protect the company's interests. And by contrast, in the class action lawsuit in Milieu-Defensie and Shell, the plaintiffs were seeking to vindicate their own rights under the Dutch Civil Code read together with the European Convention on Human Rights. And so the outcomes were different because the content of the legal norms engaged in each case were different. And that, of course, is critical. Another arena in which climate change concerns are being litigated is the field of investor-state dispute settlement, ISDS. In the case of Lone Pine and the Government of Canada, there was a legal challenge. Lone Pine was an investor which held the rights to mine for oil and gas under the St. Lawrence River, and they challenged the decision of the Quebec government to revoke exploration permits on environmental grounds. In finding that Quebec did not violate international law and the treaty obligations to accord fair and equitable treatment to Lone Pine's investments, the tribunal majority considered the environmental public policy concerns animating Quebec's legislation. The tribunal majority gave weight to the Quebec government's intention to encourage the sustainable development of natural resources with a view to protect the St. Lawrence River. I'll turn now to Singapore's environmental laws and regulations. And our judicial approach applies legal frameworks consistently with the rule of law in the light of expressed policy objectives by law and policy makers. An example of this approach is the High Court case of Ventura Navigation and PSA back in the late 80s. It concerned the grounding of a tanker in Malaysian waters, resulting in the rupturing of its tanks and the escape of oil which polluted Singaporean waters. The case turned on the interpretation and application of legislation designed to address the problem of maritime oil pollution. And the two acts were the Prevention of Pollution of the Sea Act, 1971, and the Merchant Shipping Oil Pollution Act, 1981. The vessel owner sought to rely on a statutory limitation under the 1981 Act, but the High Court held that the plaintiff was liable for the oil pollution damage that resulted under the 1971 Act because they interpreted the limitation strictly as applying only to specifically to oil tankers. The environmental rule of law operates by the consistent and logical application of laws meant to safeguard the environment, with a clear appreciation of the environmental purpose behind them. There's a further aspect that I will touch on, namely regulations meant to ensure that companies do not misrepresent the ecological friendliness of their products and services, what's called greenwashing. And to name just a few, consumers are empowered to sue corporations for an unfair practice under the Consumer Protection Fair Trading Act 2003, with the second schedule specifying that unfair practices include misrepresentations that goods or services have characteristics or qualities they do not in fact have. So this has obvious application to claims of that food is sustainable or environmentally grown or other claims of that nature. Then there is Appendix L of the Code of Advertising Practice, a self-regulating industry code of the Advertising Standards Authority. And that states that the basis of any environmental claim made in advertisements and commercials must be, and I quote, explained clearly, should be qualified where necessary. Claims of environmental friendliness must not be made unless the advertiser can provide convincing evidence that their product will cause no environmental damage. And then the Singapore Exchange's main board rules include sustainability reporting requirements and climate reporting requirements, which are mandatory for listed issuers in certain industries, the financial, agricultural, energy, building, and transportation industry. And with climate reporting rules, those operate on a comply or explain basis for other listed issuers. And this includes proper disclosures of how climate-related risks are likely to impact the company's future financial position, performance, and balance sheet. These rules keep corporate actors open and honest in their practices and transparent about the impact of climate change upon their industrial processes or the company's future financial position. The consistent, even-handed application of such rules by courts and regulators are part and parcel of the environmental rule of law, protecting the integrity of our marketplace by keeping corporate actors accountable to consumers, shareholders, creditors, and other interested stakeholders in wider society. I now turn to conservation and biodiversity. And of great concern is the poaching and trafficking of wildlife, which is not only inherently cruel to animals, but also endangers entire species. And common examples include poaching of elephants for ivory and tigers for their skins and bones. And Singapore has enacted the Endangered Species Import and Export Act 2006 to give effect to CITES, as Professor Lai mentioned. The purpose behind CITES, and by extension the ESA 2006, is to regulate the trade and movement of endangered species in order to safeguard their long-term protection. And the recent case of PP and Liao concerned individuals involved in a massive smuggling operation of live birds from Malaysia to Singapore. I've illustrated this with the white-rumped shama, an endangered bird that is a wonderful songbird. And unfortunately, sometimes in the wrong context, a talent becomes a magnet for doom and disaster, because of course that's precisely why it is getting trafficked, is because of the wonderful songs it sings. And 15 shamas died in this shameful smuggling operation. Now, in relation to sentencing, account was taken of the statutory purpose behind the legislation. The district judge observed that in the second reading of the 2022 legislation, which amended the ESA 2006 to stiffen the penalties for such offences, the government had explained, and I quote, "As an international trading hub, Singapore is committed to the global fight against illegal wildlife trade, which threatens the survival of endangered species and harms habitats and ecosystems around the world." I end on living with nature, what it means for human beings to live in harmony with nature and to work towards a world of better coexistence between humans and animals. And by coexistence, I mean adopting the mentality that humans are just one species out of many within a broader ecosystem. And as this cartoon illustrates, we may think of the animal as the intruder, but on a broader time scale, well, perhaps we are the intruder. The International Fund for Animal Welfare, or IFAW, has called this the challenge of living with wildlife in the Anthropocene being the modern era of a natural world that is dominated by humans. One of the case studies given by IFAW concerned coyotes in North America. IFAW observed how rural communities were increasingly adopting non-lethal methods of coyote management, including using guardian animals and deterrence devices and so forth, as opposed to just killing them. And that's progress. What are the implications of this for us here in Singapore? We are, after all, a city-state. In this highly urbanized environment, it is tempting to think that our interactions with nature should be regulated and controlled in our favor to serve a densely concentrated human population. Collectively, however, our society has chosen a different path, one that is encapsulated in the phrase biophilic city in a garden, used by DPM Heng Swee Keat in his dialogue with Dr. Jane Goodall in 2019. Biophilic. Well, similar to my name, Philip, which is the phil part of it, which is love, and the bio is loving the environment. So a biophilic city is one where the relationship with the environment is no longer one of domination. By this he meant that even as a city-state, we must live in harmony with nature and wildlife by integrating green spaces into our highly urbanized environment. And of course, living in harmony with nature is not easy when otters may raid one's koi pond, monkeys may enter one's kitchen, or hornbills may snatch a pet bird. And of course, those are all individual, and not more than just annoyances. They can be individual tragedies. But it requires difficult adjustments in our behavior in order to accommodate wild animals. And the onus is not just on urban city planners, but also on everyone to work together as a community to nurture and cultivate our green spaces without compromising human safety and well-being. And this shift is again underpinned by the rule of law, with the strengthening of laws protecting wild animals. Now, our approach remains that animals would be the object of laws rather than the subject of laws. The animals would not themselves be coming to court and starting litigation. But that's the way our laws work, and probably it'll stay that way for some time, I imagine. At its heart, this vision of a biophilic city in a garden reflects the shift in mindset that I mentioned earlier. We are stewards, not mere exploiters. And we must pass to our children and grandchildren a world and an environment that is once more on the mend. So with that objective in mind, let me end on a personal note. I'm also a writer, as Prof. Lai mentioned, and some of my stories have concerned animals, the environment, and Singapore as an urban jungle. In one of them, called Painting the Tiger, the protagonist, Ah Leong, takes his 2.5-year-old son to the zoo. The boy is initially fidgety and bored until he sees the majesty of the tiger. Later, Ah Leong contemplates the fate of tigers across the world and is inspired to paint a tiger. He despairs about the fate of the tiger, until his son, freshly awakened that morning, sees the new painting that his father has painted overnight. His eyes lit up, a smile like a falling tree cracked his face. "Tiger," he said, "King Jungle." The wonder, the awe, the majesty of nature is truly precious. And there's a role for others besides judges, lawyers, lawmakers, policymakers. Artists, activists, and environmental NGOs all have important roles to play. Indeed, it is an urgent issue for the whole community. And I look forward to continuing this conversation this afternoon and beyond.